Greetings, everyone. I'm very pleased to welcome you all to this webinar on the European Law Institute response to the European Commission public consultation on the simplification strategy, the digital package and the digital omnibus. We would like to welcome you to this webinar, where I would like just to stress at the very beginning that is a webinar that has been designed in a way to be certified at CPD. So those who are interested in having the certificate, they can address to the ELI Secretariat in order to request the certificates of attendance for that purpose. What is the idea of this webinar that we start in a few minutes? The idea is to first analyze the policy rationale and the objective of the European Union simplification strategy. Try to understand which are the proposed revision, the proposed amendment of the digital omnibus. We would like also to provide you an overview and a detailed analysis of what has been the proposal that the ELI response has tried to outline in order to improve a project that we fully endorse and we fully support, the simplification in order to reduce the regulatory burden in this very robust and sound digital framework that the European Union has managed to design. And also we would like to reflect on what are the implications. The implication of the digital omnibus, the implication in terms of compliance, in terms of consistency, in terms of future proof of the digital framework. In order to provide you with this overview and in order to elaborate on the main proposal, I have the great pleasure to have with me some of the co-authors, the co-reporters of this ELI response to the European Commission public consultation. I have with me Christiane Wenderhorst, Professor of Civil Law at the University of Vienna. I have with me Agata Szelika, is a partner of the SK&I and S law firm in Poland. And I have with me Bernhard Nessler, who is the Vice President of the Austrian Society for Artificial Intelligence. Thank you very much for being with me in this webinar, and thank you very much for has participated in the drafting, in the discussion, and in the publication of this very important contribution of ELI to the development and the final refinement of this simplification package. Let me please start with a very brief introduction in order to outline what is the policy context where this digital omnibus has taken place. And in order to do that, let's start with our presentation. Let's start with the first slides, please. So ELI has proposed some revisions to this digital omnibus. But this digital omnibus is part of a broader strategy. Let's go to the next slide in order to understand what is the policy context. What is this simplification set of packages that the Commission has started to work on and to produce, and we will produce in the future. So as you probably know very well, even if the European Union has succeeded in outlining and deploying a very robust, sound, comprehensive, and ambitious digital framework for the digital economy, at a particular moment, this digital framework could be considered too complex, could impose certain burdens, could make difficult for the SMEs to comply in an effective way, could raise problems of consistencies or incoherencies. So taking that into account, we can clearly see that there are a number of drivers, triggers, and maybe we can use the word irritant that proposed or provoke this reaction of the European Union in order to start a simplification strategy. We could make a distinction between endogenous and exogenous drivers. On the one hand, we have the Draghi report, Letta report, the need to ensure internal coherence and consistency in order to guarantee that this fundamental digital framework is, however, not asphyxiating innovation, is not stifling prosperity, is not imposing a very, very important burden on SMEs. We also have exogenous drivers. It's a context, a geopolitical context that is becoming more complex, more controversial, and less easy to manage. All these kind of drivers explain this simplification strategy that, as you can see, is composed of different packages in different areas with different purposes. And one of them, Omnibus 7, is precisely the digital simplification package we have focused on. Let's go, please, to the next slide. We would like to stress that ELI has decided to participate in this public consultation from the very beginning. In October 2025, we already produced a response in order precisely to put forward our proposal in relation to a targeted revision of the European Union data protection law. Many of these revisions we still consider that are relevant, and we would like to see how the Commission take this proposal into account precisely in this second stage. In this second stage, taking into account the timeline of this strategy that you can see on the left side of the slide, we have also produced this second instrument, this second response, where we try to focus on a specific selected proposal that we believe particularly urgent and pressing. The idea and the general message that you can immediately start and infer from our response is that we fully endorse this simplification strategy that the Commission has started, and we really urge the Commission to move forward with these simplification packages, and very particularly with this digital omnibus. However, in our opinion, there are certain points that should be considered carefully, that reflection and additional discussion is necessary in order to guarantee precisely that all the objectives pursued by the Commission are effectively achieved in this proposal. Let's go, please, to the next slide, where I would like to provide you with the list of drafters, authors that participated in this ELI working team, preparing this second response, the one that we are going to discuss in more detail today. Christiane, Moritz, Bernard, Agatha, Paolo, Jussi, Rania, and myself. Let me please start giving the floor to Christiane Wenderhorst. She's going to continue analyzing in more detail our proposal.
Thank you so much, Teresa. As Teresa has already said, the ELI in general fully endorses the simplification strategy of the European Union, and in particular, the proposals put forward by the European Commission. However, the ELI sees that some revisions may be necessary in order to enable those simplification packages to unfold their full potential. ELI has taken a very targeted approach and just focused on a few selected crunch points concerning three major pieces of legislation: the AI Act, the GDPR, and the Data Act. Concerning the AI Act, the working group focused on the whole setup, on should it be one or two instruments, and in particular, it focused on application dates. There was also a targeted recommendation concerning the provision on bias and discrimination detection, which we find currently in Article 10, Para 5, and might find in Article 4a. Concerning the GDPR, we focus on the notion of personal data, and also on what we call the Article 9 problem. Article 9 is the provision on special categories of personal data, and that provision poses some problems. And last but not least, on adapting the GDPR to the reality of AI development and use. Concerning the Data Act, we support the Commission's move to merge 4 central pieces of legislation, namely the Data Act, the Data Governance Act, the Free Flow of Data Regulation, and the Open Data Directive. However, we make proposals how to revise, mainly from an editorial perspective, some of the articles where we spot problems, ambiguities, inconsistencies, and the like. And we put forward a proposal how to avoid retroactive effect. Next slide, please. We have been asked ever since we published our second response, why didn't you go beyond? In particular, why did you keep silent about grok and sexual deepfakes and all that? And the answer is a simple one. ELI is not a policymaker. We're not there to take the big political decisions. We have set up an interdisciplinary team that has restricted itself to making sure the law is sound from a more technical point of view. Of course, we know that there is no such thing as merely technical points of views. Policy is always creeping in, but we're not the ones to make the political decisions. And this is why the ELI took the kind of scope which the European Commission had given to the digital omnibus as given, and only made a limited range of proposals which can realistically be taken on board or could be taken on board while the legislative train is moving. Next slide, please. That said, the ELI has taken the liberty to make a few more general statements, and there are a few things which the ELI would ideally like to see or have liked to see. And one of them is, of course, difficult to achieve as the legislative train is moving, and that is better preparation and time for proper reflections. Those omnibus proposals are great. We fully support them, but we cannot have such packages every few weeks or months. So let's get it right, and let's take the time that it needs to get it right. And we would also like to remind the European institutions that concerning the GDPR, there may be a few more problems, and we may want to make a few more changes to the GDPR in order to move towards we could call a truly risk-based approach. And in that regard, we would like to remind the audience of the first response, the one of October 2025, where we set out what we believe could be a risk-based approach. Finally, almost finally, I already said that the ELI supports the Commission's move to merge 4 pieces of legislation. However, we see that the resulting patchwork might be problematic. And so we would urge the European Commission to consider, at least in the medium term, to have a newly drafted Data Economy Act that avoids the inconsistencies that almost necessarily result from that procedure. And last but not least, the ELI would like to see a European sovereignty check for all EU legislation. We can give examples why we believe not everything is in the interest of Europe and European businesses, and we believe that it's absolutely crucial for Europe to make sure its legislation works for Europe in the very first place. Next slide, please, and over to Teresa for the amendments to the AI Act.
Thank you, Christiane. Please allow me now to start navigating through our proposal. As you know probably very well, this digital omnibus is indeed made of 2 different omnibus, 2 different instruments. One is the digital omnibus on AI, and the other one is going to be discussed later on other instruments. So this digital omnibus on AI Act contained certain proposals, certain revision or amendment proposed by the Commission. And we are going to focus on two of them that we consider particularly decisive, particularly relevant. Let's go to the next slide to present the first one. As you probably know, the AI Act in the Article 113 has a calendar for the application of the AI Act. So the AI Act entered into force after the publication in the official journal, but then there is different deadlines of different stages on which the different part of the AI Act, the different provision are applicable or applied effectively. In this calendar, we have different dates. One has been already completed, for example, the one related to the prohibited practices last year. But this year, there was a very important entry into force in the sense of effective application for the core provision related to high-risk AI system. The Commission has made an enormous effort in order to produce a standard, to produce harmonized specification, and to produce guidelines in order to ensure that there were adequate measures to facilitate compliance by the operators. Several guidelines have been already approved and published by the Commission, in particular, the ones related to what has entered into force and is applicable. For example, the notion of AI system, to which the ELI has contributed as well, and the prohibited practices according to Article 5. But the other guidelines are not ready yet. So taking that into account, one of the decisions of the Commission proposed in the Digital Omnibus is to postpone the application of some part of the AI Act. We have to say, however, that we consider this postponement regrettable, unfortunate, that we are delaying such an important piece of legislation in the European Union, but we understand that the reason alleged by the Commission is that the compliance is need to be facilitated by these guidelines, and these guidelines are not ready. That explains the proposal of the Commission in adding to Article 113, as you can see, two additional paragraphs, D and E. In particular, as you can see, paragraph D make the application of certain provision, the ones that you can see subsequently in relation to Article 6 mainly, they are made conditional to the adoption of a decision by the Commission, confirming that those adequate measures I was referring to in facilitating the compliance has been precisely approved. So we believe that this proposal required amendment for several reasons. Let's go to the next slide in order to explain our position. We really believe that businesses required certainty and predictability. That means that the businesses need to know as soon as possible what is going to be the fixed date where all these provisions are going to be applicable. Naturally, these guidelines that the provision is going to approve and publish, they are going to be an important aid, an important help. However, if this date when the provisions are applicable are uncertain, the legal certainty is going to probably be very, very limited. That is the reason why our proposal is focused on two main ideas. First, they are provision of the AI Act that probably require time, that probably required public consultation, that require more refinement, that required to be postponed in the adoption. But we believe that this digital omnibus on the AI Act should be divided, should be split in two parts. One, precisely in relation to Article 113, should be published immediately, as soon as possible, because operators should know, is the current article applicable? Should we comply with the provision this year? Should be the next year, the relevant one should be in a couple of years. We need to ensure predictability. So first proposal is splitting the proposal Digital Omnibus on AI in two. One focus on 113. Second, we propose a significant change in this provision, 113, based on two main ideas. The first idea is we do not believe that a conditionality model that is proposed is optimal. We don't think that subjecting the application of the AI Act to a Commission decision is optimal, is advisable. And that is the reason why we believe, and this is the second and clear proposal, that the application should be subject to fixed dates. You can see in this slide what is our proposal that you can find in a more elaborate way and with all the explanatory note in our document. Let me please go immediately to the next slide in order to show you our proposal in relation to another of the amendment proposed to the AI Act. Is the one related to what Christiane was referring to before, the problem of Article 9 in GDPR. As you can see, the current Article 10, paragraph 5 of the AI Act is referring precisely to the processing of sensitive personal data or specific or special categories of data for the purpose of detecting bias and mitigate bias in the context of AI systems. The proposed new Article 4A, that as you can see means that we are removing this particular allowance from the chapter devoted to high risk to a chapter that is general, and therefore that enlarge the scope of this article. However, we believe that is creating a problem in relation to Article 9 GDPR. Because first, once the Commission has decided to address GDPR and amend GDPR, is probably GDPR the right place with this kind of data processing should be addressed. Second, because precisely bias detection and mitigation is absolutely fundamental. So we need to ensure that they are easy and that they are promoted and facilitated. And the condition under which this detection and therefore this data processing can be used is too limited and too strict. And probably it is missing an opportunity to ensure that these biases are properly detected. Even more, if we moved that particular provision from the AI Act to the GDPR, where the Article 9 is, we also ensure that is the scope of application of the GDPR what is relevant, and also that is under the supervision of the data protection authorities. These are, as you can see, our main proposals in relation to the digital omnibus on the AI Act. The other digital omnibus is related to several data-related legislation, and I would like to give the floor to Agatha in order to elaborate on these proposals. Thank you.
Thank you, Teresa. If we could go to the next slide. This issue pertains to a very important topic, to the definition of personal data. As you know, in this landmark decision of September last year, Court of Justice clarified that pseudonymized data are not necessarily personal data for each and every party. And because of the meaning and significance of personal data, not only under GDPR, but under all digital laws and even beyond that, because it's also important, for example, in employment laws, we think that it is really important to have some clarity from the EU legislators on this topic. So let's look into the proposal from the Commission in this particular issue. If we could move to the next slide. Yes, we have a copy of a proposal of amendment of a definition of a personal data, and I would especially like to draw your attention to this highlighted text. It refers to onward transfers, and it says in essence that the information does not become personal for that entity merely because a potential subsequent recipient has means reasonably likely to be used to identify the natural persons to whom the information relates. So in essence, if any entity in the chain of recipients may be able to identify, according to the proposal from the Commission, we will not treat such data as personal. Whether it's really what the court said in this decision. If we look to the next slide, please, we have a copy of a section from the court's ruling, and the court actually said something different, because it said that as long as we cannot rule out that those third parties have means reasonably allowing them to attribute pseudonymized data to the data subject, we should treat such data as personal in nature. So it's something different what the Commission proposed. So trying to balance the, on one hand, clarification of the concept of personal data in the context of EDPS versus SRB ruling, and really the need of clarification in this respect, European Law Institute proposed some amendments, and we will see them in the next slides. Please, if we could. Okay. So in principle, indeed, the proposal follows the idea presented by the court that we should refer to the means reasonably likely to be used to identify the person. But nevertheless, as the court said in its decision, there should be situations when we should nevertheless apply certain safeguards or certain instruments and treat such data as personal. Such pseudonymized data as personal data. And the first case which was proposed refers to obligation to apply security measures. Indeed, the person who receives pseudonymized data and is not even able to identify them, usually such entity knows that the data may be identified by other entities, and that indeed they were personal at some point of time. So they should not make these data, for example, available freely on a website, but they should really protect them. For example, we may see an example of healthcare records provided to some service provider to make quality checks. We may see, for example, the data of shareholders provided by the bank to the entity which enables execution of a shareholder's rights in other jurisdictions. They receive pseudonymized data, but they know the data were at some point personal data, and they should protect this security of those data. So this addition was added in the proposal of a definition of personal data. The other issue which European Law Institute proposed is to make clear that this transfer of pseudonymized data to another entity where it cannot be ruled out that such entity has means reasonably allowing identification should also be regarded as situation when the data are treated as personal. The transfer data are treated as personal data. And the last situation, exactly referring to the case presented in the definition proposed by the Commission, we would like to avoid abuse, yes, because according to the Commission proposal, if the parties use intermediary, and then that intermediary will transfer. That intermediary which is not able to identify the data will be able to transfer the data to a third party that may identify. According to the Commission proposal, the data will not be treated personal. This not seems right. So here in this proposal, ELI indicates that the disclosure of pseudonymized data to another entity where it is likely to be expected that the data will be subject to further transfer to entity that may identify the natural person, it should not be treated as a transfer of non-personal data, but rather as a transfer of personal data. So we may move to the next slide.
One of the focus points of the digital omnibus was certainly to make the digital acquis fit for the age of AI, and in particular to make data legislation, including the GDPR, fit for AI. Could we move to the next slide, please? So interestingly, the digital omnibus does so in different places. We already saw that there is a provision on bias detection and a mitigation in a proposed Article 4A of the Digital Omnibus on AI, which we are criticizing and which we would like to see transferred to Article 9 GDPR. But also as far as the Digital Omnibus addresses the GDPR, we find AI-related proposals in different places. And one place is Article 9 itself, interestingly. So in Article 9, there is a proposal now by the Commission to have a new point K inserted in para 2. Just to remind everybody what para 2 is, para 2 lists the legal grounds, if you like, the situations in which you are allowed to process particularly sensitive categories of personal data. And such a ground must be given in addition to a legal ground which you need under Article 6 anyway. So Article 9 para 2 is a very important provision because it tells you and the conditions under which you are allowed to process sensitive data. And now the proposal is to have a new point K, which says that processing in the context of artificial intelligence within the meaning of the AI Act is permitted. Now, that in itself is quite surprising because it's very broad. On the one hand, in the context of is very broad. On the other hand, it's just AI within the meaning of the AI Act. And that definition is rather narrow and rather problematic in itself. Now, this point K is then partly, one could say, undermined by para 5 again, according to which when you do find sensitive data somewhere, you have to remove such data and then effectively protect those data from being disclosed to third parties. And again, we believe this is not fully ideal because it partly takes back the privilege granted by point K. It might be read even as saying that you may not process sensitive data at all, which is certainly not the intention. And then this from being disclosed or otherwise made available is very difficult to meet, in particular for open source models. Next slide, please. And the second place where AI is addressed is a new proposed Article 88C, which is specifically on processing in the context of the development and operation of AI. And now this Article 88C focuses mainly on the question of legal basis. It clarifies that legitimate interests may be used as a basis, but does so in a manner which we believe does not really go far beyond what we already have in Article 6(1)(f). And there is a para 2, and here we see a few problematic aspects, including an explicit reference to data minimization. Data minimization is problematic in itself when it comes to AI, and also a newly introduced data subject right to object, which is unconditional. The normal right to object is not unconditional, the one we have under Article 21. So this is in a way going even back and allowing less than we have under the current law. So next slide, please. This is why the ELI puts forward two proposals. The ELI would like to see all AI-specific provisions concentrated in one place, namely in a new Article 88C and Article 88D. We don't want to see them scattered across the GDPR. Now, what are we proposing? We are proposing two new provisions. And let me start with the second of them, Article 88D. Why did we suggest to have another special provision here? Because we believe that there is so much uncertainty around about when data, in particular output data, is to be considered as personal. Do we have something like personal data, and now I use quotation marks, in the model? If so, who is the controller of those data, and what are the responsibilities? And this is why we propose to have a clear provision on that in Article 88D. It largely says that output is to be treated as personal data if it can reasonably be related to that identified or identifiable person. And again, we have to take that relative approach. So if we have a deployer of AI using an AI model to generate something, and that refers to a particular party, that person may perfectly know that the data is not related to that identified or identifiable person. But then maybe when you store it and so on, it may become less clear, and it is personal data. And it can also be personal data from the beginning if that qualification that it can reasonably be related to an identified or identifiable person is fulfilled already from the beginning. So that clarifies when output is personal data. Now, the question is, who is the controller? And we say, well, normally it's definitely the party, the deployer, the other user that determines the purposes and means of processing the output, generating the output, storing the output, using the output. However, it can also be the provider, including a downstream provider, but only when certain conditions are met. First of all, let me put it bluntly, the problem is the model. This is the first condition, right? It's not something else. So the problem is the model, and that means that the personal data for which we don't have a legal basis is generated in a systematic manner. So it's not just by coincidence once in a time, it's in a systematic manner, and it was not just provided by a downstream source, such as the prompt or such as the internet, which was searched. So if these two conditions are met, then also the provider is a controller. And then finally, paragraph 4 says that we know the data is not stored in the model. That is not how it works technically. But if you have a model, if you control a model, it's as that has those kind of weights inside that can generate the same personal data time and again. It's as good as if you had the data. So this is why we propose in paragraph 4 to have these obligations when somebody controls the model. Next slide, please. So and next slide, please. So you see here that personal data may be involved when it comes to AI in several places. So they can be training and test data, they can be input data, they can be output data. And this is again to a kind of illustrate here what we mean with this Article 88D. So we want to illustrate that output data can be personal data. And one possibility why output data may be personal is that they were in the training data and that they have, and again I use quotation marks, memorized. They have been memorized. For example, because they were very often in the training data, and so the model weights are shaped in a way that makes them regenerate the data time and again. Is this a problem? Well, it's a problem if there is no legal basis. You may have a legal basis for saying that Donald Trump is the president of the United States, but you may not have a legal basis for a lot of other statements about natural persons. Next slide, please. And this is something we like to stress in Article 88D. Data being in the training data set is not the only way of having a problem. You can have a problem also where the model has never been trained with the data that we're referring to a particular data subject, and yet because of statistics, that model may, in a systematic manner, generate personal data that are then relating to a particular identified or identifiable natural persons. And that is important to note. So the training data is not the only source of a personal element in the data. Next slide, please. If this happens, so if this is because of the model weights, normally both the deployer and the provider are controllers because it's a problem that's in the model, if you like. However, next slide, please. Where the problem is not from the model, but the problem comes from an outside downstream source, such as a website that was searched or the prompts, the input data, then it's only the deployer and it's not the provider's problem. Next slide, please. So that was basically clarifying roles. And now we come to the more interesting part, maybe. We come to our revised version of new Article 88C. And so we fully endorse the policy goal pursued by the European Commission in that proposed digital omnibus. However, we would like to propose a slightly different legislative technique and slightly different way of achieving the same goal. We would like to create something which we call a privilege for privacy by design, a privilege for good and European AI, if you like. So, and we want to do this in a more technology neutral manner in order to be future proof. So we don't want to refer specifically to the concept of AI as we find in the AI Act, which is very narrow, which is very problematic, which is very uncertain. So a technology neutral and future proof privilege for good, well-designed systems. So an AI system or model is deemed to be in conformity with this regulation where A, we pass the legitimate interest test. You may say, well, we have that also in the Commission proposal. Yes, we phrased it in a way that takes more a macro perspective. Why is that important? It is important because when you train AI, you're dealing with large and heterogeneous sets of data. And you cannot guarantee for each and every data point that you have a legal basis, maybe, even if you applied all appropriate safeguards and were really, really diligent. So this is why we want to take the macro perspective and say, well, the training as such, the activity as such must pass the legitimate interest test. And then, plus, appropriate safeguards need to be applied that ensure that it's not possible to re-identify data subjects except when there is a legal ground. Remember my argument with the President of the United States. And this is now really important, the principles set forth in Article 5 are complied with to a degree that is reasonable in the circumstances. So nothing impossible, something that is reasonable according to the state of the art for people that are really anxious to get it right, to apply privacy preserving technologies and to take privacy by design seriously. And with that, I would like to ask you to go to the next slide and go and explain why we believe this is a privilege. So you already saw on the previous slide that if you do all that, your activity is deemed to be in conformity, is deemed to have a legal basis and all that. But now comes the really important point. If, despite all you have done, despite all the appropriate safeguards, something turns out to have gone wrong. Like, as I explained, you can do all that is required and still some personal data for which you don't have a legal basis may be in the output suddenly. And then somebody may exercise the data subject's right. If something of the kind happens, then you have to fix it. If it's possible without a problem, fix it, remove the data. But, and now comes the really pivotal point, you don't have to destroy the model. You don't have to make disproportionate effort, because this is what developers are afraid about in Europe. You know, that you have to destroy the model in which you just invested millions or billions of euros. So that is not required. What you have to do is, without undue delay, implement appropriate safeguards, such as downstream TOMs, technical and organizational measures, usually filter technologies, and deal with it in a more fundamental way when you do your next retraining cycle. And then there are criteria to determine when something is proportionate. And with that, I would like to hand over to Bernhard, who will explain that in a little bit more detail.
Yeah, thank you very much, Christiane. So from a practical point of view, as I'm a technician in that team, from a practical point of view, what does that mean when somebody, some small enterprise or some bigger enterprise, want to develop a model where potentially there is personal data in it? Next slide, please. So what we created by this 88C and D is that we have a certainty for the provider of the model that he is has a legal basis to train such AI models, even if there is larger heterogeneous data sets, but also in other situations where the provider intentionally wants to train on personal data for certain reasons, be it whatever models he wants to build, including the Article 9 problem. So we built the basis that we have the possibility that a provider can comply with certain rules that can be complied with. So this is practically possible. And then has the certainty that the model sustains even if certain subjects exercise their rights. So next slide, please. And that is now the image. What if something goes wrong? So the model should persist, the model remains, even if there are complaints about certain output data. The only thing that we have to do is next slide, please. The provider and the deployer have to apply proportionate TOMs. So that means you have to be aware when you build your AI model that you already integrate in the model the means that are necessary in order to filter certain things out if something comes out in the output that should not be permitted. So your model is trained in a regular way, potentially already with privacy-preserving differential privacy or whatever means you have, depending on the justifiability of your model. But even if that is not sufficient, you can be sure that if you have done all due care while developing the model, that model can persist. And now you only have to apply effective filter methods. And this is practically possible because there at this moment you have access to the outputs. So you apply filter methods that filter the output such that the data that effectively comes out of the model is not in violation of the rights of the personal subject of the personal data. Sorry. So it persists the model and it only applies filter. Now we also have, of course, the point that a deployer does not always know how to apply such filters. That's why a deployer shall only use models that are from a provider who has already pre-developed the methods for such filters and is able to provide also those filters in due time if it should turn out to be necessary. So both are responsible together for those data that really stems from the statistics of the model itself and to avoid the output of those data afterwards. Next slide, please. Yeah. So what does that mean for the AI provider? The provider has to check that his activities are in a legitimate interest, which should regularly be fulfilled. Next, the provider has to apply appropriate safeguards, as I just explained, in order to do the best in order to generate a privacy-preserving model that can be filtering out the privacy, the personal data from the training data in the first place. And as far as this is not possible, or he does not even want that because he wants some information from those data in the model, then he should do that with a differential privacy or the like method by the way, for which methods we are very strong in Europe. So Europe has a strong research focus of privacy-preserving AI, which by that way should maybe have a stronger effect also in building new models. Next, as I said, the provider has to already know potentially there could be situations where I have to apply safeguards in addition, because some data subjects have exercised their rights. So the model should already be embedded in some system that makes it easy and possible to apply additional safeguards in order to fulfill the needs for the undue delayed removal of data from the output. And of course, this is not all. There comes a time when the model regularly is rebuilt, so retrained from scratch, and it should be regularly retrained from scratch in order to have a clear, transparent connection between the training data and the model. So if you go on training the data, sometimes you would have training data from 10 years ago still in your model. This is not the way it should go. So after some years, or whenever the large next revision is due, then relevant training data is removed from the model, and those individual TOMs, those individual safeguards, filtering safeguards, can then be removed in those next revision of the model. I mean, if they are not necessary anymore. So next slide, please. What does it mean for the deployer? So you should only use an AI that, of course, satisfies these legitimate interests and comes from a trustworthy provider in that sense, because you are jointly responsible for them. You are, as I said before, responsible to apply these TOMs, these filtering methods, in a simple wording, as soon as it's necessary. So as soon as the provider tells you there are new filters, you have to apply them, even if you personally did not see that problem immediately. And in the end, you should not use a system that does generate personal data output for which you do not have a legal basis. So this is the overall gist of the idea. So the model may say the president of the United States is Donald Trump, but it might not say some things about other persons. And if it happens and if they complain, then you have to take action, but you can always be sure that the model itself, if trained in the right way, if trained with due care, can persist even though some complaints arise. With that, I may pass the word to Agatha.
Thank you, Bernard. And I will discuss the Article 9 problem, which indeed Article 9, which refers to processing of special categories of data, raises a lot of concern. I would like maybe I would like to start with solving the problem of Article 9 related to AI training and use. So if we can move to the next slide, we will find here the Article 4a and the Digital Omnibus on AI. And the first section may be known to you because it was copied from Article 10, Section 5. And the Commission proposed to add Section 2, which refers to the providers and deployers of non-high risk systems, which will be also allowed to process special categories of data for the very particular purpose of bias detection and mitigation. And of course, we know that bias detection and bias in the IA systems is one of, I would say, main risk. I would say it's one on top 3, and another similar is hallucination, but the bias detection has probably is more impactful. And when we look into that proposal, which is in Digital Omnibus on AI, I would like to remind, not in GDPR, Here, the Commission, in essence, proposes that such important issue as bias detection and correction will be, first of all, subject to very strict rules, much higher than initially stated in Article 9 of GDPR, because it says that these additional measures, which are listed in points from A to F, are applicable on the top of those arising from Article 9 of GDPR. And amongst them, you find, for example, the requirement to apply measures which ensure the security, that the data are secured, protected, subject to suitable safeguards, including strict controls and documentation of the access to avoid misuse and ensure that only authorized persons have access to such data. This is very detailed, and also it goes beyond what is required for normal processing of special categories of data under Article 9. So that's interesting that for such an important task in AI context like bias detection and correction, where we have additional increased threshold of protection. The other issue which raises maybe a question or concern from the legal perspectives is Section F, which refers to market to assessment and requirements to include special information in the records of processing activities. Under AI Act, it will be supervised by market surveillance authorities, not the GDPR authorities, data protection authorities. So again, market surveillance authorities may not be well prepared to do that. So let's look into the next slide. How it looks like in Article 9, which was already presented by Christiana. Here we have this very broad provision, at first sight, a very broad provision which refers to processing of the data in the context of development and operation of AI, which are listed here in the first point and letter K, which of course is very limited when we look into paragraph 5, how like Christiana explained. And again, we have also on the top of it some provisions which allow processing of biometric data for biometric verification on device. So here we see that we have actually, when we look into two proposals, we have some regulation concerning special categories of data in the context of AI, for example, in Digital Omnibus on AI, and we have a different regulation and Digital Omnibus related to GDPR. And of course, on top of that, the main problem, I would say the biggest problem, which refers to the definition of special categories of personal data, is not addressed in the proposal of the Commission. I'm talking about, in general, the definition of special categories of data and the grounds for processing. It means mainly paragraph 1 of Article 9. If we can move to the next slide. Of course, why I say it's a problem? It comes from the broadening interpretation of special categories of special categories of personal data. As we see from jurisprudence of Court of Justice of European Union, the court said, for example, that the personal data should be subject to Article 9, even if it's not inherently linked with a sensitive characteristic, but where it's possible to make conclusions with regard to a sensitive characteristic by way of intellectual operation. So, for example, if someone is buying, for example, 3 packages of cigarettes every day from a given shop, that then the other person may infer from that information that someone has really a strong addiction to the cigarettes, but it requires a certain intellectual operation. So it's not the mere fact of purchasing something is not exactly a sensitive information, but connection of these dots may lead to the data being special or sensitive. Another point which comes from the jurisprudence of Court of Justice is that if we have a mixed data sets which include sensitive data and other personal data, the court says that the whole data sets in general, in some cases, should be treated as subject to Article 9. So they expand the application of Article 9 also to data which are included in the data set, but not are necessarily special categories of data. That means, as I said, that we will have more and more data subject to Article 9, which may not be really required and justified by the purpose of that provision. Let's move to the next slide, please. Yes, and where Eli proposals, what is the Eli proposals proposal in connection with that? First, Eli proposes to address this main problem, the definition of special categories of data, and actually refer to indicate that the operations which will be lawful if we have and if this particular sensitive characteristics are involved. So first, it refers to processing of biometric and genetic data in nature that allow unique identification of natural person. Then point B, that concerns data that is inherently and specifically linked with a natural person, racial or ethnic origin, political opinion, religious and philosophical beliefs, trade union membership, health, sex, life, and sexual orientation. So this sensitive characteristic. And then point C, it is processing of personal data for a purpose that is related to sensitive characteristic, in particular to infer sensitive characteristic to apply a differential treatment based on such characteristic. And then such processing will be lawful according to the proposal if at least one of the cases listed in paragraph 2 of Article 9 will apply. And let's move to the next slide to see what is with respect to which cases would allow processing of such data. In general, there is a proposal to keep the existing grounds for processing and to add some new ones. The first which we propose to add refers to processing of personal data for the performance of a contract to which the data subject is a party, or to undertake steps necessary prior to entering to the contract. So this is a new legal ground under Article 9. We have such legal ground under Article 6, but we believe, especially with the special categories of data, it's sometimes necessary to perform to process them in order to perform the contract or in this pre-contractual state. With respect to the letter L, there is a proposal to keep this provision which allows the processing of biometric data on devices. And then there is a proposal to, I would say, solve this problem of scattered regulation between AI Act and GDPR when we are talking about processing of special categories of data for bias detection and correction. Eli proposes to add the additional legal ground, particularly referring to detecting and correcting bias and avoiding discrimination, and to, of course, require some adequate safeguards to be in place to prevent any use of data for other purposes. So in this sense, we would have, I would say, a complex regulation which refers to processing of data related to AI in GDPR, not scattered between various regulations. So if this provision is added to GDPR, then this Article 4A may be deleted from AI Act. The purpose is to have one complex regulation in one place and ensure in that way a consistency between the regulations. And having said that, I would like to pass the floor to Christiane.
Yes, thank you so much. So we now come to the third part, which is the revisions of the Data Act. And when I say Data Act, I mean the Data Act as we are probably going to see it, the one that will also include provisions from the Data Governance Act, from the Free Flow of Data Regulation, from the Open Data Directive. And I already said at the beginning that the ELI is only partly happy about all this. It is happy and supports the digital omnibus proposal as far as that idea of further simplification, of consolidation of the data acquis is concerned. And it is certainly overdue to have one big piece of regulation in that regard, because having a data act or data governance act and all these other more horizontal pieces of legislation doesn't make sense. Having said that, the ELI sees with a degree of concern that what we may be getting is another patchwork that may be even more difficult to navigate for businesses than what we already have. So the ELI is realistic. The ELI knows that it's not very likely that during the legislative process we will see a full-blown, fresh and consistent Data Economy Act, as we would love to see. So this is why we sat down and identified what we believe are the most pressing crunch points where we really need revisions, because things are manifestly unclear, because we have obvious drafting errors, because there are inconsistencies between the recitals, the text itself, now the Commission recommendation on model contractual terms. And these are the crunch points we focused on. So what we basically did is redraft Articles 1, 7 and 8, 11 and 12, 25 and 29, also the definition of data holder. That was the absolute minimum, where we said, well, there are really massive problems out there. We also identified massive problems with Article 4.13 and 14, and we suggest replacing them by a separate provision, as you will see. And last but not least, we see a problem also with regard to primary EU law, as many provisions of the Data Act take retroactive effect. In a way, we can discuss whether it's compatible with primary law or not. In any case, it's unfortunate for businesses in Europe, all the more as we will show in a moment, the territorial scope has not been well defined, and that there is a fear that this puts European businesses, possibly depending on how the Court of Justice will interpret the rules, at a massive disadvantage. So next slide, please. We can't walk you through all the revisions because that would take up a lot of time, maybe another seminar. We will just give you two examples of what we did and why we did it. Take, for example, current Article 1. Now, first of all, current Article 1 is terribly long and convoluted and could be shortened and simplified. But there are also massive problems when it comes to substance. So just look at the definition of the territorial scope on current Article 1, para 3. So it says this regulation applies to manufacturers, this is fine, users is fine, but then comes data holders. So these are the important provisions of Chapter 2 that decide on whether you may continue use data, whether you have to share data with the users, whether you have to share data with third parties indicated by the user. So this is a really important part. Data holders, irrespective of the place of establishment, fine. Now comes the nonsensical part, that make data available to data recipients in the Union. This is totally nonsensical because it means, first of all, that you can escape, you could potentially escape the rules by not making data available to data recipients in the Union. Even if you read this as saying that are under an obligation to make data available to data recipients in the Union, that doesn't solve the problem with Article 4, 13 and 14. So it's really bad. And same with the next one, data recipients in the Union to whom data are made available. Yes, you're not under an obligation to give data to recipients outside the Union, maybe, but if it happens, why should a data recipient outside the Union not be under the same set of obligations? And now that you have all these new parts, they are not reflected in the provision on international scope, which is probably an omission by mistake. So next slide, please. This is why we propose no longer to have that restriction to data holders making data available to data recipients in the Union, to phrase it in a way that makes sure also third country data holders are included, also to include third country data recipients, even though there may not be an obligation to make data available to them, and a reference to the new chapters are added. Next slide, please. And now I will hand over to Agatha again to give you an example where we simply thought things are too complicated and not practical.
Yes, thank you, Christiane. Indeed, if we could move back one slide back, yes, okay. Yes, we are referring to Article 4 provision, sections 13 and 14. When I ask questions to the data holders or manufacturers whether they know they will no longer be allowed to use the data their products generate because they have not that clearly stated in the contract, I would say most of them are shocked. Yes, because we should remember that these provisions apply to the data generated after September last year, but the products could have been placed on the market or offered much earlier. Yes, and so actually it applies to many products already on the market, and very often the data holders have never regulated the issue of data sharing in their contracts. So on top of that, these provisions are highly unclear, yes, because, for example, why in section 13 we refer to non-personal data which are readily available, but on 14th, when we are talking about sharing the data, we talk simply about non-personal product data. So we do not refer to those readily available. Why the difference? No, I think nobody is really able to answer that question. On top of that, we have that provision really in the section, as I said, of Article 4, which mainly refers to the mandatory data sharing between data holders and data users, and nobody expects these provisions which restrict the data holder on the use of data. So indeed, these two provisions raises a lot of concerns and a lot of doubts. Therefore, it is really important to give a clear message, to provide a clarification what is allowed from the perspective of a data holder. And that proposal is presented on the next slide. Please, if we can move, yes. And first of all, the idea is to separate it into a new provision, just to make it really visible, not to hide it somewhere at the bottom of other regulation. And it clearly says that a data holder may use product data and related services data in specific situations. And first of all, we refer to product data and related services data in general, because the idea was to create one legal mechanism that would address both the usage of personal data or product or related services data which are personal and non-personal. Of course, as it is stated in section 4, if we talk about personal data, of course, it's necessary also to comply with GDPR, but the mechanism will be, I would say, combined. We will have one mechanism. As to the grounds or situations in which the data holder may use the data, I think we decided to propose two clarification, or even to make some things very explicit, which could be seen obvious, but was not explicitly stated or are not explicitly stated in the Data Act at the moment. The first one refers to the possibility to use the data if it's necessary for functioning of the connected product or the provision of related services to the user. It seems obvious, but there may be doubts under the current regulation whether such activity is covered. Of course, nobody switches off the product or the related service at the moment, so let's hope the regulator will not read the current provisions in a strict way, but in our view, it's necessary to to clarify that. And of course, we added also the provision which allows the holder to use the product data that's required by the union law or national law in accordance with the union law, because we have a lot of provisions which put such an obligation on data holder, for example, in the motor vehicle sector, to share such information. So it was not also covered by the regulation. We have decided to skip this differentiation between using and sharing. However, in section 3, you can see that actually the proposal probably reflects better than initially intended this spirit of Article 4, Section 14, which refers to the sharing of the data with by the data holder with another entities, and actually it imposes the obligation on the data holder to bind those further recipients to apply at least the same safeguards for the user legitimate interest as the data holder has to apply. So this will protect the data generated by the use of the data coming from the product or related services data. So that's the new proposal, which let's hope will help to solve the problems arising from Article 4, 13 and 14. Thank you. And I pass the floor to Teresa.
Thank you very much, dear colleagues, fellow reporters. In this response from the ELI, we have tried to provide you with not exhaustive, not complete, but we have wanted to provide you an outline and an explanation of the main proposal that we have included in this response. We invite you to read in detail throughout the entire text that you will find properly referred in the references that we have shared with you. Now we have 10 minutes for a Q&A. This Q&A session, as you know, has to be made in writing. So we have already received a few questions that I'm going to read immediately in order to start the discussion among the speakers today. The first question is from Merlin Reitman, asking about the proposal for a new Article 8080C. The question is, to which extent this provision is expected to be applicable for public or to public authorities as well, in relation in particular to the idea of the legitimate interest. So please, I don't know if Christiane, maybe, would you like to address this question? Thank you.
Yes, thank you so much. That's an excellent question. So first of all, with the redraft of Article 88C, we wanted to stay as much as possible within the ambit already opened by the proposal made in the first place by the European Commission. And the draft of the European Commission made reference explicitly to legitimate interest within the meaning of 6.1f. So we did not diverge from that and add a special provision on public authorities and so on and so forth. You're absolutely right that the more general way the legitimate interest test is phrased in our draft could potentially also apply for to public authorities, and that is something to be discussed, whether it's indeed what is appropriate. That's a little bit more a policy question, actually, and with the drafting we proposed, we wanted to stay as close as possible to the original draft.
Thank you, Christiane. Thank you very much. I can see that there are two other questions related to this provision. May I probably just refer to them? So you can see that Clemence Danda asking about the same provision, Article 88C. The question is the following. If all appropriate safety, let me just come back to the question. If all appropriate safety measures, the TOMS, are taken, would that mean that there is no liability under Article 82 GDPR? I just stop here if that is sufficient to address the question, maybe in the meantime.
Should I, or?
Please, Christiane, absolutely.
No, absolutely. I would say that this is exactly, I mean, for Article 82, you need a breach of an obligation under the GDPR. And if you're compliant with what the GDPR in its revised form requires, then I would say there is no liability. And in fact, if we want to create something like certainty and security for AI development in Europe, then we also need to create a degree of being safe with regard to claims for damages. But of course, it really requires that you take the appropriate steps. So it's not like a blanket license to go out there and do anything you like just because it's called AI. So this is not the approach of the European Law Institute.
Christiane, thank you very much. We also have several questions from our dear former president of the European Law Institute, Pascal Pichonat. It's so nice to have you with us in this webinar. I would like to address in particular one of the questions that Pascal is putting forward, is the one related to what happened if the exception to Article 9.1k is stipulated through contract. So to which extent we could be in a situation where those exceptions are considered unfair terms. I shared with you the question, I don't know, Agatha or Christiane, naturally, Bernard, anytime you wish to intervene, would you like to address this question from Pascal? We also have questions related to, just in the meantime, the definition of digital asset in the Data Act. That meanwhile, Christiane, Agatha, and Bernard, you are thinking about the other question. Maybe I can address this one. We have always considered that the definition of digital asset is not appropriate. And it is not appropriate because it's using a term that is uniform term in international text. For example, in the UNIDROIT, the digital asset and private law. It is even common in other instrument in the context of the UNCITRAL instrument. And digital asset has a very specific definition that could be, for example, extracted from the UNCITRAL model law on electronic transferable record and the other more soft law instrument at UNCITRAL, and is absolutely based on two components. The one is the idea that we have an interest or a value represented in a digital electronic record, in an electronic record. So first we have an electronic record, and second, we have this fundamental factor of the control. So it's an electronic record capable of or susceptible of control. So this definition is so strongly embedded in the international debate that using digital assets, so this term, in a way that is totally deviating from the notion that is, as you can see, internationally harmonized, that is, for example, in the case of the MiCA regulation, not used per se, digital asset, but definitely we have references to crypto asset that would be very similar in this regard. We thought that was not appropriate to use in the context of the Data Act with a completely different definition this term. That was the reason why we consider unfortunate that term and the corresponding definition. In the meantime, Christiane, Agatha, Bernard, any other questions you would like to address, please? Agatha.
Yeah, I think I see the question from Viera Savova about the Article 4, whether I understand the proposal from European Law Institute will not make the life of the holders of pseudonymized data more complicated. I think rather not, because of course we have a higher standard of GDPR. So if we have a personal data, we are subject to, as a controllers or processors are subject to requirements of GDPR. Here we are still giving the option, yes. So with a pseudonymized holder of pseudonymized data, does not have this reasonable means for identification, it may not treat those those pseudonymized data as personal. Nevertheless, there are 3 situations under the proposal when they should undertake additional efforts. So in my view, it's better to have 3 situations in which you should undertake additional effort than in general apply all GDPR. So, I mean, it's always a possibility to treat the data as personal, and then you have this highest standard of protection. From my perspective, I don't know whether Christiane wants to add on that topic something.
No, I absolutely agree. I mean, we try to kind of restate what the Court of Justice is saying and complete the argument made by the Court of Justice in order to prevent abuse and things from happening, which I think were not contemplated. But it's still with the aim of making things easier for businesses. If I may, I would like to give also a reply to that excellent question concerning 9.2K, whether that can be done via standard contractual terms. We do have established case law by the Court of Justice on Article 6.1b, so what contract means as a legal ground. And that makes clear that this is nothing you can, in a by-the-way manner, hide in your standard contract terms and conditions. It's really about the main thing which the contract is about. And we assume that, and then the EDPB has taken the same position already before the Court of Justice said so. So of course, when it comes to sensitive data, that would have to be interpreted in a similar manner, if not even stricter, because it's about sensitive data. So I think what we already have as established case law and opinion on 6.1b would also have to apply.
Thank you, Christiane. We are about to conclude, to finish this webinar. There is other question very interesting. I'm sorry that we have not enough time to discuss in detail. Pascal, you also referred to the a very, very interesting problem about the standards. This interconnection between Sense and Elect technical standards and the legal standards in the AI Act. And I would just like to refer to 2 different issues. On the one hand is to which extent the general debate of to which extent we can really standardize even the protection of human rights in the context of the AI Act. So to which extent this idea of standards in the sense of technical standards is something that could really crystallize properly the genuine policy goals behind the AI Act. And on the other hand, as you indeed refer in your question, to which extent they are going to be ready. And if they are not ready, how much the AI Act application should be dependent upon. So it's going to be absolutely made conditional in a way that precisely we have criticized in this proposal that is not referring to the standards in particular, but in general to any kind of measures facilitating compliance in Article 113. So in a way, to the extent that we are waiting for the standards, the guidelines to be ready, the AI Act becomes an extremely vulnerable, if I may use this word, instrument, because it's extremely dependent upon other kind of subsequent instrument to be ready. So thank you very much to all of you for being with us, for the excellent question that you have shared. Thank you, Christiane, Bernard, Agatha, for the excellent work that we have done together and for being speakers in this webinar. Thank you to all the participants. Let me just conclude by saying that with this contribution, that is a second contribution after the one that we proposed last year in the first step of this process. ELI fully endorsed the simplification strategy and the simplification policy goals, so the policy goals behind this simplification strategy. We believe that this simplification is so important that has to be done rightly and in a way that is effective. And that is the reason we encourage, on the one hand, the Commission to move forward with this strategy and all the different digital and omnibus packages, and in particular digital omnibus that is working on, but to reconsider some point in order to ensure that there are not inconsistencies, that the policy goals pursued, they are not undermined, sometimes with in a way that is not clearly intentionally. Third, that we are not compromising the legal certainty, one of the examples that we have provided in relation to Article 113, and that we are not creating something that could be absolutely counterproductive and definitely undesired, is an effect of the sovereignty, the digital sovereignty, in the sense that we are adding a burden precisely to the European companies compared to those companies that are located outside of the European Union. With this contribution, ELI would like to ensure in our mission to that the lawmaking is better, is precise, and is aligned precisely with the policy goals that are sought. Thank you very much. We invite you to continue working with us and following our work. And I wish you all a nice day. Thank you so much. And thank you to our colleagues from the ELI Secretariat. Thank you.
Thank you.